We'll call to order this meeting of the Tennessee State Board of Equalization on March 4, 2025. Yeah, we'll get a little closer to the microphone here. Mr. Pope, will you call the roll of the Board of Equalization?
Yes. All right, Miss Betty Burchett. Mr. Jeff Fleming, are you joining us online? All right, we appear to be having, I know he was planning to join online. I don't think we can hear him currently. I'll see if I can message him. Commissioner Giorgano?
Here.
Secretary Hargett?
Here.
Miss Erin Merrick?
Here, and as you know, Mr. Director, I have a hard stop at 11:30 today.
Thank you. Comptroller Mumpower?
Here.
Treasurer Lillard?
Here.
You do have an in-person quorum to conduct business, as well as one virtual member who can see and hear the proceedings.
Okay, very good then. Quorum's present. Item number 2, public comment period. Mr. Pope, would you address this?
Yes. Yesterday, you all should have received a memo detailing the request for public comment that I received in advance of today's meeting, as well as additional written comments have been included with your materials. Our first commenter, Mr. Mayor, informed me that he will be unable to attend, but he has provided written comments, which I've included in your materials, and I've sent a digital copy to those joining virtually. It is my understanding that those who are wishing to comment are present unless I've otherwise noted on that memo yesterday. Generally will be called in the order of their request. You'll notice that you have one additional speaker now. Generally speaking, speakers will have 3 minutes to speak per agenda item, exclusive of questions from the board. I will hold up a marker noting when they have 1 minute remaining and when their time has elapsed. Speakers are selected on a first-come, first-served basis and are generally 2 speakers for or opposed to the agenda item. You do have an additional speaker requested as opposed to the agenda item. The board may extend the time or the number of speakers in your discretion. With that, the first speaker I would have in order would be Mr. John Key, who I believe is joining us virtually. I want to make sure, Mr. Key, can you hear us online, and can you introduce yourself to make sure we can hear you? And then I will start your time for your address comments to the board.
Hi, can you hear me?
Yes, is this Mr. Key? Mr. Key, I'm sorry, did I?
Mr. Key?
I can hear.
Sorry about that.
Okay, we can
My
hear you.
computer's messing up. Can you? Oh. Are you able to hear me? Sorry.
Yes, begin when you're ready.
Okay, thank you. Good afternoon. My name is John Key, and I've been a residential appraiser at the Rutherford County Assessor's Office for nearly 3 years. During this time, my colleagues and I have identified numerous inaccuracies in property accounts, including square footage errors, missing buildings, developmental properties on Greenbelt, and misclassifications such as properties assessed at 25% residential instead of the required 40% commercial. Many of these issues weren't immediately apparent, but after taking the initiative and advocating to attend DPA training classes, I learned critical principles that Mitchell and upper management have ignored. For instance, a home can be prorated and placed on the tax roll once it is substantially complete, not when it's sold. And properties with multiple rental units should be assessed at 40%, not 25%. I have seen this with townhomes, condos, and mobile homes. Most importantly, I learned that accounts must be treated impartially, meaning fair and equitable. Despite raising these concerns with management, many issues remain unresolved. On October 28, 2024, the DPA met with Rob Mitchell and other relevant staff. During that meeting, the DPA provided guidance on correcting over 7,000 accounts with potential errors and assured Mitchell they were available to help our management team when we had questions. My colleagues and I appreciated their help. However, aside from that meeting, management had minimal communication with the appraisers during the audit. Their primary concern was meeting deadlines, not overseeing the process. They delegated coordination to non-supervisors like an IT employee while adopting a hands-off approach. Through the review, we ran across accounts that needed to be field checked to confirm finished areas. We asked on multiple occasions to go out and complete field checks, to which we were denied and told to hang on to them. We also asked for a letter that could be placed on the doors of the houses to notify homeowners that we were there and prompt them to give us a call. This request was also denied. It was clear to us that leadership was not concerned with completing the reviews correctly just to hurry and finish them. Since then, the office has reverted back to business as usual, with management conducting zero follow-up meetings or discussions to improve our processes. We've simply been given a list of accounts to quickly review without learning from past mistakes. Meanwhile, my colleagues and I continue to uncover consistent errors on accounts, especially now that we have a better understanding of what needs to be addressed. In conclusion, fair and equitable is something I still firmly believe in, and when I review each account, but as I review accounts, I struggle to find where leadership has maintained that same belief. There are many in the office who feel the same way and are scared to come forward. We are desperately pleading for your help, not only for us, but for the taxpayers of Rutherford County. Thank you for your time.
Thank you, Mr. Key. I want to take a moment to recognize that I believe Mr. Jeff Fleming has joined the meeting. And Mr. Fleming, I want to make sure you can hear and see the proceedings for today.
Yes, I can.
All right, perfect. The next speaker, since we now only have two speakers in favor of, would be Mr. Richard Kincaid. Mr. Kincaid, can you unmute and introduce yourself and begin when you are ready? I want to make sure. I believe Mr. Kincaid is in the lobby. Mr. Kincaid, we have not heard from you. Give you additional moment. I'll confirm when we can hear you.
Can you hear me?
Yes, thank you. Introduce yourself and begin when you are ready.
I would like to ask, my statement has timed about 3 minutes and 15 seconds. Can I have an additional 15 seconds?
It's in the discretion of the vice chair.
Yes.
Okay, thank you. My name is Richard Kincaid, a residential appraiser at the assessor's office since 2022. Alongside my colleagues, I take pride in serving the public with integrity. However, under Rob Mitchell's leadership, we've encountered many ethical challenges that have hindered our ability to effectively perform our duties. From the outset, my colleagues and I inherited work zones with thousands of incomplete property records, including homes occupied for years but were never added to the tax roll. We also uncovered major errors such as incorrect footage, misclassification, missing structures, and other key details that have been wrong for a decade or more. In 2015, the assessor's office transitioned to a new appraisal system. During this change, vital data was altered, compromising the accuracy of our property valuations. Rather than proactively addressing these known issues, management adopted a reactive approach. This has meant that corrections are only made during the review process, which happens once every 4 years, or in response to taxpayer complaints. This oversight has undermined our office's ability to ensure fair and equitable property assessments. Moreover, management has routinely instructed appraisers to delay making improvement changes into future reappraisal years rather than adding them in the current year. This was done to avoid generating change notices and reduce the number of taxpayer complaints and Board of Equalization hearings, particularly during election cycles. While these actions may have minimized work, they have contributed to an unfair tax burden and violated taxpayers' rights to appeal by concealing changes to their accounts. I discussed these concerns with Mitchell directly, highlighting townhomes and condos not being added to the tax roll when completed as required by law. Rather, these properties were being added when they were sold, sometimes up to 2 years later. Mitchell acknowledged this was common practice but failed to take corrective action. Instead, he retaliated, which led to a filing of an ethics complaint. Offering corrective guidance, the DPA later identified thousands of potential errors. Rather than embracing the much-needed assistance, management adopted a hands-off approach while expecting my colleagues and me to resolve thousands of account issues spanning decades that were created under their leadership. Management even remarked that we had dug our own grave in reference to us speaking out about our concerns. In conclusion, under Mitchell's authority, state laws have been disregarded, resulting in systemic false assessments. His negligent misconduct has eroded public trust. On Facebook, Mitchell has even accused the comptroller of targeting the county in a tax grab scheme while ignoring his noncompliance. If the comptroller's office is committed to making government work better, I urge the board to help the office adhere to its oath, something Mitchell has been incapable of doing while having impunity for his actions. We hope for a positive change. Otherwise, both taxpayers and employees will continue to silently suffer for the consequences of caring. Thank you for the opportunity to voice my concerns.
Okay.
All right, thank you. I believe the rest of our speakers are in person. Our next speaker is going to be Mr. Bud Carmen. Mr. Carmen, if you want to approach the table, and then just be mindful that the red means mute and green means unmuted. That'd be perfect.
Turn on your
Oh,
mic.
we got to turn on your mic.
Punch the button there on the base of the mic. There you go.
Does this work better?
Oh, let me make sure. Yeah, you want to speak into the mic and make sure we can hear you, but
Pull it towards you. There you go.
pull it towards you a little bit.
Okay.
There you are.
Is this better? Can somebody hear me? Ladies and gentlemen, members of the board, thank you for the opportunity to speak to you. I represent Rob Mitchell, who is the duly elected assessor of property in Rutherford County. I came on board to see if I can help him in some of his communications with the Division of Property Assessments. I regret to tell you I have been unsuccessful because my communications with the director of the Division of Property Assessments have totally failed. In my request to meet with council, I was denied. We have three motions before you today. The first one comes straight from the assessor, who requests that the controller remove himself from this discussion because of an obvious conflict. Second motion we have is that the charges of noncompliance be dismissed for failure to meet the requirements of law, TCA 67-5305, having been disregarded in the matters that come before the board. I could not spend enough time today to get into the technical details where disagreements occur. But the threshold issue we ask is a determination of probable cause of whether there has been a violation of state law in bringing matters to this board. It is simply fundamentally fair to deal with that issue. TCA 39-16-402 speaks very clearly that a public official, a public servant, it was referred to in the statute, has committed an offense when he acts outside the authority of his office. By definitions that are listed in the glossary of terms by the controller of the treasurer, the assessor is the one charged with responsibility to classify property, not the Division of Property Assessments and not the controller. The classification of property has been delegated to the assessor. And if there is a disagreement on the classification of property, then that matter is for the courts. There is no state agency authorized to speak, to clarify a statute when that statute is either ambiguous or if it does not speak to the issue at hand. And it would take a little bit of time to get into the specifics of what I'm referring to there. Understand the majority issue in Rutherford County is the classification of property that is used for dwelling purposes. Residential property is classified by the assessor as residential property. That amounts to 80% of the impact of the differences in valuation in the assessor's office. The errors that staff speak of, I know of some of those errors. You know, we're set up on a 4-year cycle for review property, and it's not unusual in any county in the state of Tennessee that you'll find errors at one particular point in time where the property has not been inspected for at least 3 years. So you have three issues: the classification of property, the correction of errors, and the prorate of assessments on property where there's been construction commenced after January 1 and completed before September 1. The assessor has a plan in respect to all three of these areas right here. But back to the initial matter at hand, we state very clearly our desire that the matter of whether state law has been violated by the controller himself for acting beyond the power of his public authority. We request, before going forward, a ruling on that motion. Thank you.
Okay.
Thank you. The next person who requested to present public comment would be Mr. Rob Mitchell, the Rutherford County Assessor of Property. Mr. Mitchell, if you want to come up to the table and get situated. Reminder, the red light means mute, the green light means go.
There we go. I'm Rob Mitchell, Rutherford County Assessor of Property. This is not where I wanted to spend March the 4th. I have very little to say except that it is very easy to twist words into falsities. I categorically deny everything that Mr. Kincaid and Mr. Key allege. The lack of any direct oversight is due to their involvement in a lawsuit, at which point I was told to not have anything to do with them. I was to distance myself, and that was by counsel. Now, the other allegations as far as directions, we have inexperienced staff. They do not know the processes of Rutherford County. There is a difference between a certificate of occupancy and a certificate of completion. Our staff has always been directed to pick up property as they find it substantially complete. That has not changed. My residential supervisor, manager, Mr. Lance Jenkins, who has more than 30 years in appraisal, has his TCA. We follow the same processes that we have followed for more than 20 years. We follow the same processes that were in place under Tommy Sanford, under John Barbie, under Mr. Bill Boner, and myself. Our last appraisal in 2022 was spotless. If you look at the comments by DPA staff, they will tell you how easy we are to work with, how transparent we are in process. Now, whether you choose to believe that this is a political hit job or not is for you to decide, but it is not germane as to part of the operations of this office. We have been cordial and open to the Division of Property Assessments, granting them full access. They determined which queries were to be run. They assigned them to administrative staff at their request to distribute to appraisers. They instructed the appraisers on how they were to conduct their positions and how they were to do their jobs. Administrative staff then, at the direction of the DPA, picked up those reports, conducted quality control, sent them back through the administrative staff at their direction to appraisers to correct, at which point they deemed that once they were corrected, they were ready to be submitted. Since October, we have not essentially been in charge of the office. The Division of Property Assessments achieved key cards outside of their authority and went directly to the county mayor. I was not aware of the request. No apology was made on their behalf for oversight or even an acknowledgement that, Mr. Mitchell, we got these keys. We hope it's all right. We should have asked you. So I believe that this action against me is politically motivated. We're in the middle of a reappraisal, which has to be finished by January the 1st of 26. These operations are disruptive to the operations of my office and is a disservice to the citizens of Rutherford County. I respectfully cede any additional time I have to anyone else who may wish to speak.
Okay.
And then, sorry. In accordance with the rules adopted by the board, we do have one additional request at the discretion of the vice chair, if you'd like to hear from Ms. Coleman. It's within your discretion.
From who?
Ms. Stephanie Coleman with Owings, Wilson, and Coleman.
Okay, let's have Ms. Coleman come forward.
Remember, make sure you got green means go. So
Good morning. My name is Stephanie Coleman, and I'm an attorney with Owings, Wilson, and Coleman. A few weeks ago, the attorney that worked primarily with Rutherford County and its property assessor's office, Mr. Robert Lee, unexpectedly passed away. My law partner, Doug Overby, and I are in the process of working with Rutherford County through the process of being retained. But that, of course, requires certain approvals and meetings, and we are not yet authorized to represent Rutherford County or its Office of Property Assessments. So our request today is simply that the board would consider taking a little extra time and giving us an opportunity to be retained by the county in order to represent it in this matter.
Okay, thank you.
that concludes the board's public comment period for this meeting.
Okay. All right, very good then. Next item on our agenda here at the moment, we're just going down the agenda here, is item number 3 is review of the minutes from October 14, 2024. Is there a motion, comments, changes, et cetera, to the proposed minutes? All right, motion for approval by Secretary Harg. Is there a second?
Second.
All right, we have a second by Commissioner Jared Gano. I guess we have to call the roll since we have a member on the video here.
Yes, thank you.
Or members on the video.
Miss Betty Burchett? Okay. Mr. Jeff Fleming?
Yes, sorry.
All right, thank you.
Commissioner Giorgano?
Yes.
Secretary Hargett?
Yes.
Miss Erin Merrick?
Yes.
Councilor Mumpower?
Yes.
Treasurer Lillard?
Yes. All right, item is adopted there. Those minutes are adopted. That concludes that item. On item number 4 is the next item, which is review and consideration of the report of noncompliance of the Rutherford County Assessor of Property. Mr. Pope, you want to introduce this item?
Yes. So the Division of Property Assessments has found that the Rutherford County Property Assessor's Office is either unwilling or unable to comply with Tennessee's assessment requirements. In accordance with Title 67, Chapter 5, Part 5, that being Section 505, the division is then required to report such a finding to the board. You will hear in a moment from Mr. Kinsey his report under that subsection. You, the board, are then required to notify the assessor of property and the county mayor of the nature of the noncompliance and indicate the action required to correct that noncompliance. In a moment, you will hear from Mr. Kinsey, who will identify what actions the division believes is necessary in order to correct that noncompliance. The assessor's office or the county will then have 60 days to take such action as specified by the board. If satisfactory action is not taken, the board shall direct the division to take any necessary steps to ensure Rutherford County assessments are brought into compliance. You should have with you copies of the relevant Tennessee code sections as mentioned in the division memo and as cited by Mr. Carmen. In preparation for today's meeting, I do believe you have heard from Mr. Mitchell. I do believe we have several other attendees, including Mr. Christensen from the Rutherford County Attorney. I also made sure to send a copy of the notice of today's meeting to the county mayor. And then you do have that written request from from Ms. Coleman regarding the representation as you heard during the public comment. Unless you have further procedural questions, we'll hand it over to Mr. Kinsey to make his report to the board.
Okay, let's recognize Mr. Kinsey and proceed.
You went to get things started.
Good morning, members of the board, Mr. Chair. My name is Brian Kinsey, and I am the Director of the Division of Property Assessments. Under the authority of Tennessee Code Annotated 675-505C, I'm here today to deliver a report of noncompliance regarding the Rutherford County Assessor's Office. This is an unfortunate and serious situation that could have been avoided. And without immediate corrective action, it will leave the taxpayers of Rutherford County with assessments they cannot have faith in. You have my written report, but I'm going to spend a few minutes showing you just some of the many examples of the assessment deficiencies occurring in Rutherford County. As we go through the slides, you will see how the county had ample opportunity to right its course and give its taxpayers accurate and fair assessments. Instead, I'm here today asking you to compel the county to assess properties in compliance with all applicable laws. Like I said, a few slides here, a few examples. But first, I want to walk us through the timeline, how we got where we are today. This started back in the fall of 23. The division's just routine monitoring and then subsequent complaints that we received from multiple sources allowed us to zero in at that time on at least two areas of concern: improvements, or new buildings, in other terminology, being left off the tax roll. Objective, or in other words, quantifiable, measurable, observable changes to properties not being assessed in the correct tax year. As a result of these, the division met with the county and issued 2 audit findings related to these 2 specific issues. The county concurred and assured us there would be corrective action taken. However, as we proceed on into the months following, we continued to receive complaints regarding these issues and additional reports regarding square footage errors in buildings. We reviewed these complaints and we find them to be valid. That leads us to September 2024. Comptroller Mumpower sends a letter to the assessor on September 11th, 2024, expressing serious concerns with the assessment practices that are occurring in Rutherford County, and further directs the Division of Property Assessments to enhance its oversight of the county. That enhanced oversight began in the fall of 24. It began with meetings. The division met with the county on multiple occasions between October and November 2024. Together, we developed a plan for corrective action. We zeroed in on 4 major categories of concern, and we established for the county a completion deadline of January the 3rd, 2025. The 4 major areas of concern are noted up there on the slide. Objective changes being pushed to 2026, and again, that's measurable, quantifiable changes not being assessed in the year in which they were created, in which the objective change occurred, but pushed out to a future tax year to delay the assessment of these changes. Another issue is a proration of new construction, square footage errors, and assessment classification. So again, that's the October-November timeframe. A plan of corrective action, 4 major categories identified, a deadline established of January the 3rd, 2025. In December of 24, Mr. Mitchell, the assessor, met with Comptroller Mumpower and requested that that deadline be extended all the way out to September 1 of 2025. It was the holiday period. Comptroller understood some of the challenges the office was facing over the holiday period and did grant a 30-day extension. So moving that deadline from January 3rd to February 3rd. That brings us into the relatively current timeline, the winter of 25. Again, deadline February 3rd. On February 3rd, the county did submit through shared file, shared folder online. They did submit lists that they reviewed, corrective action they intended to take, and they also provided data that was being used to generate change orders to send to the collecting officials. After a day or so of reviewing that, we realized there was some information missing. We did notify the county that some information was missing. On February the 7th, they did again submit through the shared folder additional data that was related specifically to change orders for the 2023 tax year where square footage corrections were needed. Again, we received some data from them on the 3rd, on the 7th. It took a few days beyond that. But ultimately, after reviewing all the data submitted, the division did find that the county is not in compliance. In fact, let me just go ahead and point out, some of the very changes that the county processed, we reviewed and determined that even the corrections were incorrect. So, again, if you recall from a couple of slides back, I had identified 4 major areas of concern. For the purposes of this non-compliance discussion today, we really only focused on 3 of those. The first one, we did see a reasonable enough attempt at the county level to not make it part of this non-compliance discussion today, and that was the issue of pushing changes out to a future tax year. So again, that one was taken off the table, which left us with 3. And I'm going to discuss these 3 and give you some examples that are pretty clear, pretty obvious examples of what leads us to this discussion today. The first one involved proration of new construction. I've got a snippet, a quote of the statute up here, the relevant statute, 675504. It requires that all assessments be made annually as of January 1. Well, as we know, and it was mentioned in some comments earlier, not every building is complete as of January 1. So we have to look a little bit further into the statute, into 603, that provides guidance on how do you handle that situation. How do you handle the situation of a building that is partially complete as of January 1? But remember, the law requires that assessments be made as of January 1, 675504, even for incomplete buildings. So the first example I want to go through with you on proration, this is an example of a dwelling in the city of Laverne. You can see a date stamp, and quite honestly, I can't read it on this screen without putting on my glasses. But you can see a date stamp on that photo of February 23, 2024. February 24, it was well underway, right? You can see it was well underway in its construction. You see on the left an image from the City of Laverne Codes Department, which deemed this building to be complete and ready for occupancy in May of 24. Pretty reasonable, based on the picture you see from February, it's pretty reasonable to believe that by May this building was complete. However, the assessor's office didn't assess it as of May 24. They assessed it as of August 24. And that taxpayer, based on the information I've seen to this point, did not receive a correct change notice that properly prorated that dwelling. As a result, the tax bill on that property was at least $400 or more too low. Here's another example of proration. In this case, we're looking at a somewhat unique building in the city of Murfreesboro. I only say it's unique because it's a 4-unit building. It's a 4-unit building that the city of Murfreesboro Codes Department said was ready for occupancy, complete, in October of 2023. You can see in that photo, hopefully you can see the upper left corner of that photo, you'll see a date stamp of February 6, 2023. You can see that even in early 2023, this building was well underway. So again, it's not a stretch of the imagination to believe the City of Murfreesboro Codes Department when they say it was ready for occupancy in October of 23. Which means it should have been assessed for the entirety of 2024. It was ready on January 1, 2024. There's no doubt about that. What actually happened, 3 of the 4 units that sold in late 2023 were put on the tax roll as of January 1, 2024. One of the units that didn't sell until March of 24 wasn't prorated until March of 24. So it's clear this building was ready in its entirety on January 1, 2024, and it should have been assessed in its entirety as of January 1, 2024. There were some notes in the assessor's documents that stated they couldn't find a certificate of occupancy. We were able to find the certificate of occupancy. I have it on the screen for you. Here's another example of proration. This rather elaborate dwelling is, again, it's also in the City of Murfreesboro. You can see the date stamp on that aerial photo, January 9, 2023. Again, that photo is taken January 9, 2023, showing a substantially complete structure. Now, granted, this building drug on for a while. I don't know all the reasons for that. That's not for me here. That's not for me to even discuss. What I do know is a permit was issued for this dwelling in June of 2021. What I do know is that the law says even an incomplete structure must be assessed if it remains incomplete for 12 months, I'm sorry. The exact law says, in no event shall any improvement or new building be considered incomplete for valuation or assessment purposes for more than 1 calendar year, immediately following the date on which such construction was commenced. So, assuming construction commenced at the time the permit was issued in June of 21, by June of 22, there was potentially an assessable there was an assessable improvement there, even though it was incomplete. You can see from this photo by January 1 of 2023, it was substantially complete. But I'm telling you, the information that we have seen says that this building was not partially assessed in 22. It was not partially assessed in 23. It was not assessed in 24. In fact, it remained in what the Rutherford County computer system, CAMA system, Computer Assisted Master Appraisal System, refers to as pending for 3 years. It said in pending for 3 years, which means essentially for 3 years, this property owner was only paying taxes on the land, no building value. All right, the second issue I would like to discuss with you today, and again, these are just a few examples. Square footage. I'm not going to read that statutory citation word for word. It's there on the screen. You can look at it. But essentially what it says is when an assessor discovers an error in their records, they are required to correct that error. Well, there are errors in the square footages in the Rutherford County Assessor's Office. This first example here, this is a home that I think most of us would agree when we discuss it just briefly has an obvious discrepancy in the square footage, even to the untrained eye. What's listed in the assessor's records is a house with 1,911 square feet upstairs, an 1,890 square foot garage, and then the main living area, what's the acronym SFLA, square feet of living area, the main living area on the ground floor, 1,310 square feet. Again, I would say that even to the untrained eye, you can see that that's highly unlikely that those square footages are correct for that upstairs and that garage. The county did review this property according to the notes that we've seen, and they noted a small change needed to the upper story, but it didn't appear to grasp the entirety of the problem. So at the end of the project, This parcel did not receive a change order that properly corrected the square footage and valuation error. This is the same property on the left, the one I just showed you on the prior slide. This on the right is a house right next door to it. You'll notice immediately some differences in those square footage and those values, and those differences are attributed entirely to an error. You'll see the house on the left, the one we just talked about, 3,221 square feet is what the assessor's office says it has of living space. The house on the right has a much more realistic 2,008 square feet. You see the value differences. The one with the error is valued at $563,700. The one that it does not have the error is valued at $346,500. The owner of the property on the left did not receive a change, but should have received a corrected assessment for tax years 23 and 24, which would have amounted to approximately a combined $2,000 refund. Here's another house with a square footage error. It's a similar situation. I mean, even to the untrained eye, you can see the house is listed with 1,560 square feet upstairs, while the downstairs has 1,566. I say to the untrained eye, but I'm going to give you a couple of more pictures to illustrate that. It's pretty obvious that the upstairs in a house built in this style would not be similar in square footage to the downstairs. To further illustrate that, here's a back view of the house. I mean, you can tell that the roof on this house starts sloping, from the ground floor. It's not like this, which would allow the second floor to have as much square footage as the first floor. It's first floor and then like this. So to assert that the square footage upstairs is as much as it is not supportable. If that wasn't convincing, here's a side-by-side comparison of the house on the left, the one I just talked about, that's erroneously listed with 3,126 square feet, literally the house next door with essentially the same floor plan is more correctly listed with 2,042 square feet. You'll see the one on the left is valued at $427,300, while the one with the correct square footage is valued at $330,800. There was an attempt to correct this one. And again, I said a few minutes ago, when we reviewed this data, we determined that even some of the corrections were not correct. This is one of those examples. The owner received a refund of $19.70, but it was based on a flawed premise. It was based on an incorrect correction. The closer amount should have been around $1,338. So moving into the third and final area of my presentation today is the third area of noncompliance, assessment classification. Couple of sections of code here, 67.5, both coming from 67.5.501. Subsection 4 defines for us that all real property that is used or held for use for dwelling purposes that contains 2 or more rental units be classified as commercial property. It says industrial and commercial, but for the sake of the day, we'll just say commercial property. Subsection 11 provides a definition of residential property, includes real property that is used or held for use for dwelling purposes that contains not more than 1 rental unit. It goes on again to talk about the commercial differentiation, where all real property that is used or held for use for dwelling purposes that contains 2 or more rental units is defined and shall be classified as commercial property. As you may recall, just from your general experience, residential property is assessed at 25% of its estimated value, whereas commercial property is assessed at 40% of its estimated value. In this example, we have a property here that consists of 2 rental units, which are owned by a rental LLC, yet assessed as residential property. That's an aerial view of that property that has 2 rental units in it, along with a snippet from some of the notes that were documented in the assessor's office and shared back with us for review, where they have deemed it that 25% in that comments column is correct, and in that next column, no change is necessary. In this second example, we have 4 units in a property being assessed residentially, 4 rental units, 4 units for rent being assessed residentially. Similarly, and I'll show you on the next slide, the county's review notes acknowledge that it's rental property and note no change. And that's the snippet from that, where the review notes indicate the properties are classified as residential. You'll see in that column under comments 25%, that next column no change, that next column identifies that they are 4 units of rental property assessed at 25%. Okay, the past couple of examples have been about rental dwelling type units. This is a different scenario, but it's still a classification scenario. This is a new charter school that was built in Rutherford County and assessed by the county as residential property. We just read the definition of residential property. It's a dwelling that is used or held for use for dwelling purposes. I don't think anyone could argue that a charter school is a dwelling. So, it clearly doesn't meet the definition of residential property. When the county picked up this property in late 2024, they certified it to the collecting officials as residential property. You can see here on the screen the tax notice that came out of the Rutherford County Trustee's office as a result of the assessor's classification of residential property, where this property was appraised at a little over $4.9 million, assessed residentially at 25% for $1.2 million. The review notes in that snippet there at the bottom show you that essentially they decided that residential was okay because it was eventually going to become exempt anyway in their estimation. So they determined that no change to this property being assessed as residential for 2024, no change was needed to correct that. I started my presentation with a timeline going all the way back to November 23 to February 25. You can see by that the Division of Property Assessments has spent several months working with the county to help identify issues and encourage changes in their assessment practices to ensure that they align with applicable laws. Unfortunately, we find that the county is either unable or unwilling to comply with various requirements under Title 67, Chapter 5, Part 5. And I'm here today requesting your concurrence with that finding and a directive to the county to correct all the noted matters of noncompliance pursuant to 67.550C. 67.505C. Before I step away, I just want to reiterate what I've shown you is a handful of the problems in Rutherford County. We could likely spend days going through all of them. And I want you to know, my duty to report this to you is not something that I take lightly. It is not the easy thing to do. It is the right thing to do. It's the thing that I must do. And I also want to say, throughout this process, people have asked me to quantify this problem. Questions like, how many taxpayers are being overassessed? How many taxpayers are being underassessed? Our best guess is hundreds, if not thousands, of properties remain.
Mr. Kinsey, I hate to interrupt, but I just want to make sure the board knows you have 10 minutes remaining.
I'm sorry, what was that?
We have 10 minutes remaining in the meeting, so just be mindful of your time. Thank you.
Okay. Again, the questions, how do you quantify this? Our best guess, hundreds if not thousands of properties remain affected. But the truth is, the problems are so widespread and prevalent, I can't stand here today and give you an exact number. That would require a much deeper dive into this county. I think it's important to note, Rutherford County is one of the fastest growing counties in Tennessee. And because of that, this is true with any county, but Rutherford, it's one of the fastest growing counties in Tennessee. It's imperative, it's critical that the assessor of a county like this does his job and does it correctly. And if we find ourselves in a situation where that's not happening, we need to step in. Our Constitution requires equal and uniform assessments. Our laws provide us guidance on how to achieve that, and the taxpayers in Rutherford County deserve that. They deserve fair and equitable assessments so that when they pay their tax bill, it's something they can believe in, it's something they can trust. I believe that we have an obligation to ensure that the taxpayers receive fair and equitable assessments that they can believe in. And again, this is not a duty that I take lightly, but I am here today providing you this report of noncompliance on Rutherford County. That's all.
All right, before we let Mr. Kinsey go here, does any member of the board have any questions? And Mr. Kinsey, any quick questions of him? All right, thank you, Mr. Kinsey.
Now, it's up to the board's discretion at this point. I believe we're under that 5:05. I know Mr. Carmen has asked for time for rebuttal. I do know we have a hard stop at 11:52. It's up to the board's discretion as what action to take next, and or if you would like to call on anyone additional, you may do so.
Mr. Carmen, how long does it take you to do rebuttal, do you think? Here, there you are over there.
I will take what time is available. I have two approaches. First one is an understanding of what is the reaction of the board to the motion for the determination of probable cause. That's the first thing.
Yeah, well, I'd like to hear your whatever brief rebuttal that you may have to what's been said today, and then we'll address the matters of substance before the board at that point in time, so.
I just request that you give me about a minute notice, if you will, and then I will stop if I may sit back here. Respectfully submit, ladies and gentlemen, that you've heard a series of half-truths. I sat and listened to this presentation, and in my mind, in practically every one of them, I framed a response that could have been drawn up where you could read it. You've heard some general allegations, but you've heard some specific allegations, such as the school, where there was an application for exemption on file when you made your report and you knew it. The property is not even taxable. Why would we have a presentation where we talk about a school assessed as residential when it's not even going to be taxed? In terms of finding an error in a property listing, may I respectfully submit to you that when you have a county with 130,000 plus parcels of property, and you're dealing with mass appraisal, you're going to find some errors. In the 1970s, the reappraisal programs were conducted by the Division of Property Assessments. There were errors. There was set up a program of reviewing the properties, and the assessor's on a 4-year schedule. That is, 25% of the properties are inspected annually. But on a given day, when you go to inspect a property or an area of a property, it may have been at least 3 years since the last inspection. You're going to find some errors. 80% of the assessed value of the properties at issue by the Division of Property Assessments deal with the classification of property. 80%. That simply means that the Division of Property Assessments has entered the offices of the assessor of property and determined that residential property that is used for dwelling purposes is to be classified as commercial. You heard very little about the issues involved in that determination today, but the fact of the matter is that 67.501, paragraph 11 is ambiguous. It is unclear as to the definition of residential property. You put two people in the same room and you'll get two different answers to the same question. If you own two properties and you rent them out, single-family detached residential properties, the Division of Property Assessments would have you believe that those two rental properties are properties under state law that constitute two or more rental units when one sits on one side of the street and one sits on the other side of the street. That's just simply not true. When I discussed this with a gentleman who has great memory of how we got to where we are today with classification, I said, would you think the legislature would they have in any event intended to leave the door open to classify residential property as commercial under these circumstances? And the answer was a resounding no. The General Assembly would not have done that. There is a bill pending before the legislature that classifies residential property as residential property if it is used for dwelling purpose and contains only not more than one rental unit. The violation of due process is so obvious in this that it needs to be reviewed very thoroughly in terms of how the Division of Property Assessments has acted. But I come back to the threshold question of whether any state agency is a controlling authority as to the classification of property, as to the assessor's judgment on the appropriate date for prorating assessments, as to a 4-year plan for reviewing areas. No state agency is authorized to do that. This is a matter for the assessor, subject to review by the administrative judge that's assigned by the State Board of Equalization. You have a series of half-truths presented to you today that are simply not sufficient for determining that the assessor is in non-compliance. The error rate is so small that it is ridiculous to assume that we have a willful violation of state law. The question that I ask you is this: what is the significance of the charge that the assessor has violators in noncompliance with state law? What is the significance when we respectfully suggest that an agency of state government has stepped outside the bounds of its official power? You got two different positions. Is this board seriously going to ignore the position that the controller has exercised power beyond his official authority? Are we just going to ignore that? Thank you.
All right, thank you, sir. All right, I wanted to start off by commenting that that we're here today under, as both parties have cited here, the statute 67.5.505C, particularly. There are other statutes that could be applicable as well, that sets up a 60-day period for the assessor, if the board were to adopt the resolution that's before it today, to take action to correct the issues that have been brought forward by the Division of Property Assessment. And I would just note that if such a finding is made by this board today, then I would hope that the parties would meet during that time period and attempt to resolve these matters that are before us at this particular point. Because that's the statutory scheme that the legislature has set up. It's been on the code for a number of years, and obviously it's a point in terms of the forum to resolve issues like the ones that have been discussed here today. On the other items here that counsel for the assessor has raised through the motions that have been made. I'll take them a little bit out of order here. The motion to recuse that has been filed, in my view, is a matter for each member to decide whether he or she wishes to recuse themselves under any particular circumstance. That is not within the purview of the board to order a member recused under what has been discussed here today. The other motion for determination as to probable cause relating to misconduct or other acts, that is a matter that's in a different title of the code, and there are procedures to bring that to fruition if a person wishes to do that in another forum, in another place. This board does not have the authority to determine probable cause. We're an administrative board, we're not a court. And the other thing I'll observe is on the first matter that was raised by counsel for the assessor, the motion to dismiss, in my personal view, there is a basis to go forward under 67.5.505C today. And again, if the parties, can do so, they need to use the 60-day period to try to get to the bottom of each of the items that have been alleged and either resolve those or they remain unresolved and they'll be subject to future proceedings. But again, the statute sets forth this period of time for a reason, I think, and it's part of the process the legislature prescribed to resolve these matters. And in that regard, I move to adopt the proposed resolution submitted for adoption by the staff in this matter. And also, I move as part of that to dismiss the three motions filed by the assessor. Are there comments or debate by members of the board on that, or a second?
Second.
Any comments, questions, or anything by members of the board? All right, seeing none, Mr. Secretary, would you call the roll of the board members on that motion?
Ms. Betty Burchett. Mr. Jeff Fleming.
Yes.
Commissioner Jaragano.
Yes.
Secretary Hargett.
Yes.
I believe Ms. Erin Merrick had a hard stop at 11:30.
Right.
All right. Comptroller Mumpower.
Yes.
Treasurer Lillard.
Aye. Did you call Jeff's name on the?
Yeah, he said aye.
Okay, all right. So we have a vote in favor of that motion, and it is adopted by this board. Is there further business to come before the board?
Yes. So we had all present members voting aye except for Ms. Merrick, who's not here.
And I want to add before we close today that in the manner of making sure that we seriously have considered each of the issues that are raised by the assessor and also by the Division of Property Assessment, I know I have read every one of the papers that was filed in this matter with us and everything very thoroughly by both sides, and I'm sure other members have done that as well. So this is not a matter that we take lightly, and we will hope that during the 60-day period involved here that things move in a positive direction. So with that regard, is there anything further to come before the Board of Equalization today? All right. We have a second?
Second.
Second. All right. Call the roll on the motion to adjourn.
Ms. Betty Burchett. Yes. Mr. Jeff Fleming.
Aye.
Commissioner Jaragano.
Aye.
Thank you.
Yes.
Secretary Hargett. Aye. Ms. Erin Merrick again is absent. Comptroller Mumpower.
Yes.
Treasurer Lillard.
Aye.
You are adjourned.
All right. Thank you.